Take your seats, please. The show is about to begin. Thanks, everyone, for sticking around to the final session of RightsCon 2016. I'm Peter Misek of Access Now. I have the pleasure of introducing the first speaker, the keynote on this panel, who is Mark Stevens, CVE. So Mark is a British lawyer, media lawyer, representing a whole host of clients from different sectors, artists, musicians, free expression organizations, and individuals. With a 4-decade career, Mark has represented miners in the most bitter industrial fight in British history. He's represented Julian Assange, the leaker of WikiLeaks, and he's fought to decriminalize homosexuality across the Commonwealth. Shortly after representing Assange, Her Majesty the Queen named Mark Commander of the Order of the British Empire for his work on human rights and the arts. The arts have a deep kind of history running through his veins. He's a huge ska fan, I just learned, and and he toured working for Pink Floyd as well. So yeah, we have the pleasure of hearing from Mark, who the Times called one of the staunchest defenders of freedom of expression on the planet. So let's make him talk about privacy. So Mark's going to start off just talking about the history of kind of UK surveillance, as well as its role among other intelligence agencies in the world, the context of the review of surveillance laws going on right now in the UK, and some specific problems with the bill that's been proposed. Thanks.
Thanks, Peter, for that generous introduction. And of course, I think with the allusion to 4 decades, he was saying I was old as well. I hope that didn't slip past to the keeper anywhere. So I am old, and I'm old enough to remember the history of this. And if you'll forgive me, I'm going to talk a bit about the Investigatory Powers Bill, but I think you have to understand it in context. And I think, you know, the best place to start is perhaps in 1984 in the European Court of Human Rights in Strasbourg, which found in a case called Malone against the United Kingdom that the UK's phone tapping regime wasn't up to snuff and fell and was delinquent to international standards of human rights. That led in 1985 to the government passing the Interception of Communications Bill. You have to understand that in the UK, we have a Gordian knot of legislation, practice notes, sort of administrative regulations and such like, which all weave together. And frankly, the only people who understand it at all, really, are the lawyers for the intelligence services. You might almost think that the legislative Gordian knot was there deliberately to obfuscate rather than to make things clear. That Interceptions of Communications Act led to another case in the European Court of Human Rights in 1997, so it lasted about a decade and a bit. And in Holford against the UK, it was again criticized. That led to in the year 2000, the Regulation of Investigatory Powers Bill or Act, which included things like the ability to command the mandatory decryption on request, prison sentences if you happen to forget your encryption key. So there was those kinds of things which were rather genially included by the British government. Then, of course, we had the Snowden revelations, which gave a degree of clarity to some of the activities that were going on, and people then went back and kind of put the slide rule across the behaviors of the state against what we then knew. And 2 reports were commissioned, one by Sir Nigel Scheinwald, a very senior Mandarin in the British government, and the other, David Anderson QC, who was a slightly more independent-minded barrister, and he reported back on in a report called A Question of Trust. That, of course, led to new legislation, and that's led us to the Investigatory Powers Bill, which has been introduced into Parliament this year, and it will be on the statute books by December. There have been a process of discussions around it. They've listened to people, but they have ignored them. So it's important to understand that. It was also interesting that they divided up those that they consulted with into three effectively. The companies, who got some very, very minor reforms. So basically they couldn't be compelled to decrypt stuff that they couldn't decrypt. I think that was the concession to them. Then there was, oh, somebody got the irony of that. Then there was the NGOs, and they were put into a group, and they were given airtime with very lowly civil servants and not listened to effectively. And then there was the Global Network Initiative, which I'm the independent chair of. And we were given some time with some fairly senior civil servants, some of whom are at this conference and have spoken. So that was quite an interesting issue. I think that the backdrop to this is also, one should say that, both the state and, privacy campaigners agree about one thing, that a comprehensive review and reform is absolutely necessary. So I think that those, the government has sort of split the data into two. Communications data, which is basically the mapping of all the communications that have occurred, to whom, when, logs, all the rest of it. That information is going to be free, available, on demand to, say, the police or a whole host of other bodies without a warrant, without any judicial oversight at all. I'd be interested to hear what the audience thinks about that. Oh, say a bit louder. They haven't heard that in London yet. Then there's the content of those communications, what the person's actually said or sent and that kind of thing. And there's a couple of other powers which are worth picking up. Communications have to be held for a year, irrespective of whether or not they're going to be looked at, so that on the off chance they may need to look at it. Interception and reading of communications are approved, have to be approved by a warrant from a politician, from the Home Secretary, currently Theresa May. They have put in place what they call a double lock system. So once the politician has said it's okay to intercept the communications of a particular individual or target them, then it goes to a former judge or a currently sitting judge. It's not yet clear, but certainly not sitting in a capacity as a judge, just someone who's sort of got eminent legal qualifications. So what they've done is this kind of sprinkle some judicial fairy dust over the process, which says that once the Home Secretary has made a decision, then a judge will give it a sort of blessing, and the fact that he's a judge has some magic powers. It's of course not reviewable because he's not sitting as a judge. She would be reviewable, I think, but only on a judicial review basis that, she'd acted so far without her powers that no reasonable person could. There's also powers to interfere with computers, to hack, to acquire information, and there's also a newly imposed obligation on companies to assist officially sanctioned hacking operations. So the telcos, the ICT sector are now going to have to actively encourage and assist, as opposed to just sit mute. And of course, there's the collection of these massive amounts of data. But you can have encryption, but there's still this power to compel decryption. And we saw, even under the previous regime, how powerful that was when a journalist was arrested at Heathrow Airport whilst carrying data from Russia to Brazil. So I think that's quite interesting. I just want to say a couple of things about what is said to be safeguards. There are said to be this double lock I've spoken about the politically approved interception, which then have to be double looked at by a former judge. This Intelligence Security Committee is going to have to inspect the security agencies. Unfortunately, they're not being given a budget that would necessitate or allow them to do that effectively or efficiently, but that's part of their role. And they've also got to explain to the public how the powers in this bill are going to be used. It's interesting that the bill, the draft bill, has now been reviewed by 3 external bodies, effectively. Well, let's say external. One is the Joint Committee of the House of Commons and the House of Lords, very eminent, informed elected officials who propose serious amounts of changes. The Intelligence and Security Committee, which is usually the lapdog of the security services, came up with a significant number, I think about 140 proposed changes. And RUSI, the Royal United Services Institute, which the name may give away that it's the services and is filled with spies and former spies, and they also gave it some criticisms. A couple of the criticisms which I'd sort of like just tease out, as Peter asked, was one, there's no probable cause standard. 2, the judicial approval is absent except at the highest levels and the most intrusive things. There's, of course, this blanket data retention without any attempt to justify the proportionality of the invasion of everybody's privacy without having any interest in specific individuals. And so the purpose of this mass surveillance isn't articulated anywhere particularly cleverly. And effectively what they've done is that they've gone to take the powers that Edward Snowden revealed were being used and put them on a statutory footing. I suspect that the informed will not have expected them to do anything else, and it's why they're not changing, even when they had very heavy criticisms. And I think that there are some real questions around whether or not this particular piece of legislation will reach the smell test in the US when there's a sort of data pooling issue. There is another issue which I think we should just be aware of, talking about data pooling, is that this is about interception of communications, and it doesn't affect data pooling. And of course, there's no legislative oversight in relation to data pooling, and effectively the Five Eyes are pooling, and that's where most of the data is coming from. So this is very much about data information washing, being able to get washing of information, or getting information in a form which is presentable to a court and legitimized. So I think that's part of where we should go. So I would like to just kind of leave it there. I think I've posed some of the questions that, but there are others that come out, and I'm happy to comment on those as we go.
Yeah, thank you, Mark. Those were very helpful comments. So I'm going to introduce our other 2 panelists, and also just note that I think you're all very likely familiar with Slido at this point because we're 3 days into the conference. But just to remind you, please ask questions through Slido. It's the Cottage is the room, and we're obviously happy to encourage participation. So Estelle Massé is my colleague. She worked for Access Now as well as Edry, based in Brussels. She's a policy analyst, and then I also have Danny O'Brien, who is the international director of the Electronic Frontier Foundation. So I'd like to delve into a bit, just a little bit more of the substance of the bill, and it's obviously very complex and convoluted, and we don't have time. If we focus the entire conference on the bill, we still wouldn't have time to really address anything. But just to highlight a couple things, Danny, I know that one of the focuses for the EFF has been this equipment interference. Which what does that mean? Is it interference? What does that mean? And what?
So equipment interference is what would be called in the United States tailored access operations, and for almost everybody else, it means hacking. And as Mark brilliantly said. I feel like I'm on like this route of cynicism about the British government and the nature of law, and I'm like halfway there, and Mark has had the experience to get all the way. And so my experience was halfway through that story, which was the Ripper Bill. So that was my first experience of how the British state attempts to comply with external requirements for them to write down what they would otherwise do. And the part of the reason for the existence of the Investigatory Powers Bill, it's partly driven by Snowden and the revelations, but it's partly this idea that the compliance that they've been forced to take essentially requires them to do stuff in accordance with law. And so they get to write the law, and as long as it's in accordance with that, then they feel that they might have a chance of being able to do it without it being instantly thrown out at a later stage. So equipment interference is kind of interesting because this is something that GCHQ not only has done for many years, but it's sort of its crowning glory. If you look at the Snowden revelations, the slides from the NSA describe their practices and their policies and so forth are very disturbing. And GCHQ is sort of like this younger crazy brother who's sitting there going, we can do everything. Like we'll just go out and hack the world. And these are the possibilities that we have. What this bill does is not only legitimize and legalize that practice, it also extends it, because as soon as you start describing the powers and the potential of being able to break into a laptop or break into a phone and access the data that's on it, but also transform it into a surveillance device. Each one of these devices we have here has a little microphone, has a little camera. As soon as you begin to understand the potential of that, almost anybody in any part of government realizes that would be tremendously useful for executing their bureaucratic or law enforcement function. So the first part of equipment interference is it's not just for spies anymore. Law enforcement can use this, the tax service can use this, and the customs can use this. It's also not just limited to the UK, of course, because the GCHQ's attempted reach was globally, that you could hack into routers, you could steal secrets from Belgian companies and so forth. So it's also global. It does have this strange sprinkling of compliance, which I want to touch into a little bit more, but the real poison in this pill for me is that obviously law enforcement doesn't have a special hacking team unless they pay hacking team, the company, to do it for them. But they don't have the built-in capabilities of GCHQ. So what the Investigatory Powers Bill grants them is the ability to take the warrant that they have to hack into a device or a group of devices. We have these thematic warrants, which you will know in the Declaration of Independence as warrants general, these ideas that you can just apply a warrant to a class of people. Take those warrants and take them to what's described in the bill as communication service providers, and they will do your hacking for you. Communication service providers is described incredibly widely. Basically, if you deal with electromagnetic radiation in your job, you're a communication service provider. And this was the point, and I'm not kidding you at all. This is not a joke. This was the point when we were looking through the bill and the code of practice that I turned to my colleague at EFF and said, I'm getting the drinks out. And we sat there and we poured a hard drink because we realized at that point that communication service provider applied to local Wi-Fi's. It applied to the library. It would apply to the BBC. It would apply to anybody who writes an app. It would apply to anybody writing open source software like Mozilla. It applies to anybody who acts as a conduit for communications. Any of those people can be served with this order and be required to not only hack their own customers by adapting or changing the capabilities of their software, but hack anyone else. There's no limitation there. So to give an example, and this is the example that, of course, GCHQ actually does, and so this is what it's designed to allow, you can place malware in a watering hole, as it's called. So that's the idea that you would go to an advertising company and say, we would like you to deliver malware in a targeted way, because we know you know who your advertisers are, your audience are, and we would like you to put malware in your advertising network and distribute it to this class of people universally. Okay. So that's one part of it. So this applies to everybody. The second part of it is that it's secret. So there's a gag order attached to this. You can't tell anyone. And the third part of it, that if you view it through the lens of what GCHQ already does, this is the important part. So if you follow the Snowden revelations, or you just watch a lot of James Bond style science fiction, right? You will understand that what GCHQ and the Secret Services do is they don't, when they need somebody to do something for them, they don't go and knock on the door of the senior executive of that company, right? They either plant someone in that organization, and GCHQ explicitly says they do this, or they nobble and blackmail someone to do it. There is no description in the Investigative Powers Bill of who you approach in a company to say, please break in and hack this infrastructure. There used to be. In the RIPA bill, Ross Anderson and a group of really strong advocates managed to squeeze in to the provision that said you must hand over your private keys, a requirement that it had to go to a senior executive. There's actually bits of this in other parts of the Investigative Powers Bill, but it's not in this. So I have a massive set of concerns with this, because basically people here understand, and this is why we all collectively freaked out, to use the local term, about Apple versus FBI. We realized that that was a line that we had to draw, because as soon as Apple becomes the agent of the state, everything is literally rewritten. The code is rewritten. The functionality of everything you use is rewritten. There is no trust anymore. There are plenty of provisions in the rest of the bill that I think are incredibly weak, that basically say, if we serve you with a national security notice, if we put a technical capability service notice on you, there will be some element of oversight. There's very little oversight in this, and this is where the backdoors will happen. This is Apple versus FBI, and it's already pre-written. And for every single statement by Theresa May and anyone in this administration that there are no backdoors and there are no requirements to decrypt, that's because they don't need it. This is a backdoor as big as the entire ICT industry. And at that point, I stopped reading and started drinking. So I'll end.
That was a very sobering assessment, so thank you. Estelle, so part of the rush to get this bill done, according to the government, is that they have this power, they have data retention powers that are expiring in December, because it was ruled, the current powers were ruled not to satisfy domestic and regional human rights standards. So now that we're approaching data retention again, are we doing it in a way that satisfies the court's concerns?
Well, worse than before, actually. So basically, for those of you who don't know, the European Union had a harmonized framework on data retention, sort of, which required every European Union member states to introduce data retention mandates for a period of minimum 6 months and maximum 2 years. This piece of legislation was declared invalid by the highest court in the EU 2 years ago. But we had an issue here that the piece of legislation was a directive, which means that it's not directly applicable in the member state, but every country has to have a legislation that implement that laws. And the member states most of the member states were arguing that even though they don't have the requirement by the European Union to have such a legislation, as sovereign state, they still have the right to continue to have data retention mandates. So we had a trend where some EU countries were repealing data retention, and then we had other EU countries like France and the UK who took this opportunity to extend their data retention mandate. The UK started to do that through the DRIPA, which is currently now facing challenges in front of the European Court of Justice. And the hearing will of the government and of the plaintiff will actually take place next week in Luxembourg. So we're hoping for a swift ruling on this piece. But through the IP bills and the investigatory power bill, the UK seeks to reintroduce data retention in the law. The problem is all the standards that the court has set in order to declare data retention invalid are not in place in the new measures proposed on data retention in the IP bill. Mostly on safeguards. The European Court of Justice didn't rule out data retention as a measures completely, but explained that it's such an intrusive measures that when you consider doing it, a set of safeguards needs to be in place. First of all, blanket data retention is not acceptable and it has to be targeted to specific suspect. It cannot be indiscriminate. Then you need to have a proper right to redress, and then you need to have an approach on the time that is necessary and proportionate. None of this language or none of this safeguard is currently in place in the IP bill, which means that if sent back to the European Court, we already know that it's not meeting the standard that's been established by the law. One of the reasons why the UK is pushing for that is that France, after the attack it suffered last year, changed its data retention approach and extended its data retention mandate to 8 years in some cases, and 11 years in specific cases. So the UK is sort of claiming that the action taken by France, which are overly broad, sort of gave them the legitimacy to also go completely outside of the standard set by the EU.
Great. Mark, you mentioned this in your opening remarks, but there's a question on here about vesting the power to approve surveillance in the judiciary. And it's a common refrain in the United States. We hear people talk about the UK standard as a question of whether the UK standard satisfies human rights obligations, and that warrants are not always approved by judges. You mentioned this Judiciary Commission. Do you think that the commission and the second review by the Judiciary Commission does that satisfy obligations under the ICCPR and the European Convention?
No, I don't think it does. And let's just go back and look at this a little. First of all, if you've got communications data, if you've got a very small amount of communications data which can be accessed, that may not identify an individual, but any reasonable amount is going to, because we're creatures of habit. And as a consequence of that, they're going to be able to reverse engineer who that person is very, very quickly. And they're going to become very adept at that. There's no notification, either pre or post, that you're being targeted in this way. And therefore, there's no effective remedy to say, actually, you shouldn't be looking at my data, you shouldn't be invading my privacy. So I think it fails on all of those grounds. But just going back to the point that Estelle made, which I think is perhaps the bull point in all of this, which is that you've got to justify on the narrowly tailored, proportionate, meets the mischief basis that we're all too familiar with, that the retention of data on a blanket basis meets that test. And the UN rapporteur on terrorism, Ben Emerson, who's an eminent QC and human rights lawyer in London, has already put in his reports that he doesn't think it does. And he's actually there to report on terrorism and countermeasures for terrorism. So if he doesn't think it does, I think that we're off to a pretty retrograde start. And of course, the other rather ironic thing is that the Home Secretary has to verify that, in her opinion, that the piece of legislation meets human rights standards. So she has already certified to Parliament that, in her opinion, this is human rights compliant. And I think, it's not going to take, well, it won't take a moron in a hurry to work out that it hasn't done that. And it will be, I think, increasingly unpicked as we go. And I think this is part of the problem that the security services have with this bill. I don't think they're entirely, happy with what they've got, because they want clarity. They don't want lawyers being able to get into their systems and expose through court cases what's going on. And so as a consequence of that, they would much prefer to have a much clearer operational bill, and also one that works internationally. And I think they are smart enough to realize this doesn't actually achieve those objectives.
Just to add to, I agree. I think there's a real tension. You know, there's a lot of explanation as to why this is written as broadly as it is, and the standard explanation is, well, we want to plan for the future, right? We can't anticipate what technology will be like, so why don't we say everything that uses electromagnetic radiation? And I think that there's an interesting thing that we've sort of picked out here in the panel, which is there is a life cycle to these bills. These bills start out. They start out broad, they get broader in their interpretation. So with the RIPA bill, in our most paranoid wanderings, we sat there and going, well, who does this apply to? And by 2 years in, the surveillance powers in that were being used by the Milk Marketing Board and local councils. And then it gets reined in. Once again, everything I say is actually literally true. So this gets reined in again. And then, but by that time, these powers have become established and used. So one of the things, so the next bill just describes current practice. One of the things that I really actually do encourage people to read, not necessarily the bill, but the codes of practice that are associated with them, because they're actually pretty clear in the sense of that you can look at them and go, this is excessive. But some of the subtle granularity of it, and again, I'm going to dive in on the equipment interference. So we talked a lot about like the responsibility of the Home Secretary, the politician who gives the stamp, and also the sprinkle of legitimacy. So in equipment interference, there's actually two forms of order that the Home Secretary signs, and one of them is for law enforcement and the tax office and customs and their powers of equipment interference. And in those orders, it's actually listed what law enforcement wants the communication service providers, everyone, to do. And that's spelled out, and the Home Secretary has to determine on a case-by-case basis whether that's necessary and proportionate. Who decides that? The Home Secretary. That's the end of the story. With the intelligence services, there's a description of who the target is and why they're being targeted, but what the communication service providers are obliged to do is not described. It's explicitly a different document, which is to say, when this order lands on the Home Secretary's desk, they don't know what the intelligence services are going to go out and ask Apple or Mozilla or whoever. And looking at this, I can only assume that this is for plausible deniability purposes, right? This is the part of the reason why all of this is so disturbing to me is that the intelligence services, the NSA, GCHQ, all of these groups have traditionally been placed in the deep state. They're supposed to do things that politicians can deny happen, or at least, you know, don't follow the rules. That's what they're there for. By drawing them in, by attempting to write laws about them, they're essentially writing null laws. They're essentially writing laws that are designed to allow them to do anything. I just end by pointing out how this virus extends. If you go to the Code of Practice on Equipment Interference in section 6.14, I feel like I'm reading from the Bible now.
You are.
Chapter verse, open your books to this page. Section 88(5)(b) of the Act makes lawful any conduct undertaken by a person in pursuance of requirements imposed or on behalf of a person to whom an equipment interference warrant is addressed. This, therefore, and this is what I mean about the Code of Practice actually spelling out what is implied, this therefore authorizes activity taken by communication service providers and giving effect to the warrant that would otherwise constitute an offense under the CMA, that's the Computer Misuse Act, the data protection legislation, or other relevant legislation. This means that they give you an order, and if that order is against the law, it's okay because you're allowed to do it. So for anybody who's a system administrator or a network administrator in an organization, you know that you could do anything, right? Like you're basically being held back by your own ethics and the fact that there's probably another system administrator who will catch you doing it if you mess around. But you know the extent of the power that you have. Here's an order, a secret order that you can't talk to anyone about, that compels you to do something and tells you if it's against the law, that's not an excuse. You still have to do it. And that's the the first time we thought that maybe the bill might have this in it before the code of practice came out. We were submitting to the 3 committees, and there was a section that my colleague Eva Galperin wrote that called this the James Bond rule, right? That this is basically a 00 license, right? And I cut it out because I went, first of all, as a Brit, we're a bit sensitive about the James Bond stuff, and secondly, like we'll be laughed out, right? Like this will be, people accuse us of confusing fiction with fact. I sat next to a senior figure from one of the secret services, and under the Chatham House rules, so I won't say. I'm probably already in trouble. But anyway, he described like our characterization of this as paranoid, and that it would all be clarified when the codes of practice came out. Codes of practice came out. I just read you the codes of practice. That's specifically what they say, and they spell out data protection and they spell out Computer Misuse Act. That's what you're going to be asked to do. You're not even going to be asked to break the law. You're going to be asked to do anything that they want, and told that that isn't breaking the law.
I think just picking up on something, I mean, I think that you've made that point incredibly powerfully and well, but I think the other point, of course, is that the Home Secretary can't be complying with human rights law when she signs the warrant, because she doesn't know what it's going to be used for. So how can she make a determination of proportionality in her compliance? It seems to me that, you know, it's got these kind of built-in flaws, and, you know, lawyers are going to be crawling all over this, and, you know, for those that have got money to pay, it's going to be a bean feast, I hope.
So we have a question up top, and so there's been a lot of movement on surveillance in the EU. We have a request to specifically give a numerical evaluation comparing the UK bill with France, Turkey, and Russia. Whether or not you're comfortable with the specific request, how do you think this compares, and how much influence was there in passing legislation elsewhere that provided the coverage for the UK to pass something itself?
So I'm not really good at attributing numbers, but I can try to make a sort of comparison there. There is a lot of similarities in the bill that is being proposed in the UK to the 2 bills, or 4 if we had the 2 bills that were passed 2 years ago in France, in terms of scopes, in terms of issues being dealt with. I would say that the UK bill is much more detailed, and we actually have much more information of what is actually going to happen in the UK. But they're similar in the sense that both of them are trying to put into a legal framework a situation that was happening for a very, very long time. A lot of what has been codified in France was the practice and was known and was revealed by the Snowden revelation. And they tried to legitimize this practice by making it the law and explaining we're being transparent about the fact that we're doing the surveillance, not understanding that the transparency part was not really the issue. It was more the fact that it was happening. Then we also have the issue of the actual breadth of that surveillance, because both the UK and France has a big history in having empires and colony. And if you look at the map of what constitutes the French territory at the moment, a lot of people are thinking of Paris and the surroundings. But if you look at the map, it's actually tons of islands around the world. And you have this international surveillance bill that allow any French authority to tap into undersea cable passing through its territories. And if you're considering the island that France owned in front of the United States, the territory that France owned in Latin America, the numerous islands that France owned around India, the ones in Africa, the one in the Pacifics, it's actually very big. And it's not only surveillance in France and around France, but it's global surveillance. And the same situation applies to the UK. So when we're talking about surveillance in UK and France, you have to think about global surveillance as well.
I mean, being an old rock and roller, I think that to use an analogy, they've just turned the Marshall amps up to 11. I'm glad that Estelle raised the question of undersea cables, because I think that's the big blind spot that nobody's looking at, because suddenly they're saying they're all extraterrestrial. The question asks, you know, how does this rank with Russia? I used to live and work in the Soviet Union, and a lot of the people who I came to know from the KGB, now currently renamed FSB, You know, they had the capabilities that we've got. They're just less obvious about it. So I think, you know, basically we're in the same bracket as Russia, China, the United States. What you're seeing is a quick glimpse under the petticoats of what the government can actually achieve.
We're going to move to a question from the audience.
Thanks, my battery's dead. So I sort of appreciate in one sense that the UK is trying to comply with the legality principle, but the legality principle says not only that government action has to be established in law, but that law has to comply with international human rights standards. And this relates a little bit to another question here. And it's interesting to see how the UK has reacted over the years to decisions of the European Court of Human Rights and amended its surveillance powers accordingly. But now, the UK has called the Human Rights Act into question. It's debated, I think, withdrawing from the European Convention on Human Rights. It's possibly withdrawing from the European Union. How do you see that element, the international human rights, the international legal order, playing into the debate around this bill?
I mean, I think that if the current government has its way, it will come out of the European Convention on Human Rights. The argument is that there's absolutely no difference between English human rights and those Johnny Foreigner ones across the channel. But I think in reality, the British government will be far more restrictive in the way in which they interpret them. The British courts will be far more reticent about striking down legislation, particularly when the government utters the words national security. We all know how courts are very fawning in those circumstances and not at all careful or diligent in their scrutiny. So I think there really are problems. On a sort of practical level, it's quite clear to me that the cooperation that we're seeing through Europol to combat terrorism, the intelligence sharing, that kind of thing, is operationally pretty good. And that will continue, and the sharing